All right. So thank you all for joining us today for the webinar South Africa versus Israel at the ICJ from the perspective of international law and genocide with renowned international lawyer and Zoryan Institute board member, Professor William Schabas. My name is Megan Reed, and I'm the Deputy Executive Director for the Zoryan Institute, and I will be the moderator for today's session. For those of you who are joining us for the first time, I do see some new names. The Zoryan Institute is a nonprofit organization that is dedicated to raising awareness on issues relating to genocide, human rights, and diaspora homeland relations through research, scholarship, and education. Founded in 1982, the Institute is known for its oral history collections and archives, scholarly publications, international conferences, its annual graduate level university program, two peer-reviewed academic journals, and more recently, its online educational programming, such as podcasts, teaching tools, and webinars like the one we are hosting today. My colleague Sam Hall will be sharing a link to our website in the chat box where you can learn more about the Institute's work in programming. So take a look at that if you're interested in learning more. So the world, as everyone knows, is currently facing an unprecedented number of humanitarian crises fueled by escalating conflicts. Over the past handful of years, many states have turned to international law, and more specifically, the Genocide Convention, to hold states accountable for their actions. There are currently 5 pending cases at the International Court of Justice based on the Genocide Convention. This is a record number since its adoption in 1948. Dr. Schabas's timely session today will explore one of these cases, the ongoing case brought by South Africa against Israel. On December 29th, 2023, South Africa filed an application instituting proceedings against Israel concerning alleged violations by Israel of its obligations under the Genocide Convention in relation to Palestinians in the Gaza Strip. In this session, Dr. Schabas will provide an overview of the legal arguments at the heart of this case. He will also examine how international law is used to address allegations of genocide and consider the broader significance of the proceedings for the global legal order and for efforts to hold states accountable for mass atrocity crimes. We will be allocating 20 minutes at the end of today's session for a brief Q&A with Dr. Schabas. We kindly ask that you wait and hold all questions until the end of this session, and you can either raise your hand or submit them through the Q&A chat box, and we'll address them at the end of the session. I would now like to introduce our speaker today, Professor William Schabas. Dr. Schabas is one of the world's foremost experts on genocide and international criminal law. He is Professor of International Law at Middlesex University in London, Emeritus Professor at Leiden University and University of Galway, and Distinguished Visiting Faculty at the Paris School of International Affairs. A veteran of international legal forums, he has appeared before the International Court of Justice and the European Court of Human Rights, and served as chairman of the UN Commission of Inquiry into the 2014 Gaza conflict. He is the author of numerous landmark texts, including the newly released third edition of Genocide and International Law, the International Legal Order's Color Line, the Customary International Law of Human Rights. And as earlier mentioned, he has served as a Zoryan Institute board member for almost 2 decades, and he is also a longtime faculty of our annual Genocide and Human Rights University program. So Dr. Schabas, thank you so much for joining us today to host this session.
Thank you, Megan, and it's a pleasure. I wish everybody there good morning. I guess it's good morning in Toronto for those of you who are there. I'm coming to you from London, although I put a screen background up on my Zoom, which is from the courtroom of the International Court of Justice. Of course, I'm not actually there, but that's the courtroom in The Hague where all of these great events take place that I'm going to be speaking about in the minutes to follow. This is really one of the biggest cases at the International Court of Justice in its history. And I'm going to start by talking a little bit about the background of the case, the legal background, and some of the issues that are involved in all litigation before the International Court of Justice. And by way of background, too, I want to say a few words about the background between South Africa and Israel. As I'll explain in a little more detail in a few minutes, one of the the special features. I don't want to say it's unique because there are other cases like this, but it is a phenomenon, and one that's very recent at the International Court of Justice, of states taking cases to the court um, where they're not what we call injured. This is a jargon that we use at the International Court of Justice, but typically in litigation, the person who takes the case, the plaintiff, the person who files the suit, we call them the applicant at the International Court of Justice, has a has suffered some sort of harm, and they blame the respondent, the defendant, for the harm. But in this case, South Africa is there. We'll use a Latin term for this, erga omnes. It's written on another slide, so you'll see how to spell it. The Latin term just means that every state can have an interest in one of these cases because, in a way, every state is injured by the fact that a state is violating the law in question. And of course, when we're talking about situations of this kind, the law in question will be a treaty dealing with fundamental rights, typically, or the environment, or something in which you could say that the community of states has a general interest and a shared interest. And so that's one of the special features of the case of South Africa versus Israel, because South Africa is not claiming to be a victim of genocide perpetrated by Israel, but rather South Africa is taking up the cause really of the Palestinians. But they have a history together, South Africa and Israel. And so I want to just say a few words about it. Neither state um, was well, South Africa was a founding member of the United Nations, but it was then a white supremacist state and soon became an apartheid state. We date apartheid from the election in South Africa in 1948, and of course, apartheid is now has a pejorative sense, but it was the term that was used proudly by the white supremacist regime in South Africa in the 1940s and in the decades that followed. Israel, of course, wasn't a founding member of the United Nations. It didn't exist at the time. It became a member in 1949, and in the early decades of the United Nations, Israel often took what might be called a third worldist approach to foreign policy or to international affairs. And so, on a number of occasions, it actually voted in favor of resolutions condemning apartheid. Uh, the Western states in general, who are today closely allied with Israel, would always abstain or vote against them, including Canada. But Israel, from time to time, would vote in favor of a resolution condemning apartheid. Here's an example from the early 1960s, where the spokesman was Golda Meir, who went on to be the prime minister of Israel. And she's saying here in paragraph 101 of the minutes of the United Nations General Assembly, she's talking about the apartheid policy practiced in South Africa. And she says the philosophy that the color of a person's skin places upon him the stamp of inferiority is opposed to the basic truth that all men are created equal. And she says the people of Israel feel deep abhorrence for all forms of discrimination on the grounds of race, color, or religion. And this is one example among others. And the relations between Israel and South Africa continued to deteriorate during the 1960s. And I think by 1966, they had even withdrawn their ambassadors. But in 1967, everything changed, and of course, 67 was the year of the conflict that led to the occupation by Israel of Gaza and of the West Bank and of East Jerusalem. And when that happened, Israel's policy started to shift, and it became very, very pro South Africa. I've got an illustration up here. This is when the apartheid president or prime minister, I guess he was, of South Africa, his name was Verwoerd, Hendrik Verwoerd, came to Israel, and there he is visiting with Menachem Begin, who was the prime minister of Israel, and Moshe Dayan, who was the head of the armed forces in Israel. And they were exchanging weapons. Israel was assisting the South African apartheid regime. They, amongst other things, collaborated in sharing information about nuclear weapons. At a time, Israel presents itself today as being opposed to proliferation of nuclear weapons, but that only counts for Iran. And back in the 60s and 70s, Israel was actually assisting South Africa in its attempt to obtain nuclear weapons. Well, obviously, that all shifted in a way with the fall of the apartheid regime. And since the fall of the apartheid regime, the relations between Israel and South Africa have not been good. And of course, post-apartheid South Africa, originally under President Mandela, has taken up the cause of Palestine as being being a very important part of their values and of their interests. The Germans call it Staatsräson. But of course, when the Germans talk about Staatsräson, it's their excuse for their support of Israel. But let me say a few words about the International Court of Justice generally. It's one of five what we call principal organs of the United Nations. So it's the Supreme Court, if you want, of the United Nations. Um, it's governing the law that it's governed by is the Charter of the United Nations and the statute of the court, which is actually an annex to the Charter of the United Nations. And the court fulfills important roles in the system of the United Nations, both in resolving disputes or in addressing disputes between states. That's what South Africa and Israel is. That's a dispute between two states. Um, and it also issues what are called advisory opinions. And these are opinions that are issued at the request generally of the General Assembly. It can also be of the Security Council, but usually it's the General Assembly for legal guidance from the International Court of Justice. The 15 judges are elected to terms of 9 years. Every 3 years, we have an election of 5 of the judges. There's a considerable global diversity. So there's a judge from South Africa, there's a judge from Japan, a judge from Somalia, a judge from Uganda, judges from Brazil, from Mexico, several from Europe. I think the last time Canada had a permanent judge at the International Court of Justice was back in the 1950s. It's very competitive and very hard for a smaller state like Canada to get a place on the International Court of Justice. The jurisdiction of the court in disputes between states. So I mentioned that the court can issue what are called advisory opinions, and these have to be the result of a resolution by the General Assembly. But when states want to take issues before the International Court of Justice in a conflict with another state, the court has to have jurisdiction, and not all states in the United Nations have accepted the jurisdiction of the court. So the general rule is that a state can make a declaration under what we call the optional clause, where they accept basically all disputes before the International Court of Justice. They're saying we can sue another state, and any state can sue us if they have a dispute. We're prepared to go there, whenever we have a quarrel with another state. And Canada has accepted the optional clause, and it has right now a couple of active cases at the International Court of Justice. Israel accepted the optional clause back in the 1950s, but it withdrew it in 1985. And so the optional clause is not going to get Israel into the International Court of Justice. South Africa did much the same. It accepted the optional clause in 1955, but it withdrew in 1967. So we have to find another pathway to get to the International Court of Justice. And this is through what we call compromissory clauses. So this is when you have a particular treaty that allows for a dispute about the treaty to be addressed by the International Court of Justice. And in the case of the Genocide Convention, which has now 153 states that have ratified it, 140 of them are bound by Article 9 of the Convention, which you can see the text there. It says that the dispute between the parties to the convention um, can be submitted to the International Court of Justice at the request of any of them. And so it's on this basis that South Africa and Israel are before the International Court of Justice. And there are some other cases before that are there, also based on Article 9 of the Convention. It's possible for there to be a dispute about the Genocide Convention that's based on the optional clause. And we have one of those cases that's currently before the court. That's the one between Nicaragua and Germany. And I can say a few more words about that a little later. So South Africa, as I mentioned, was part of the was subject to the jurisdiction of the International Court of Justice by virtue of the optional clause from the middle of the 1950s until the middle of the 1960s. Nevertheless, there were several advisory opinions dealing with South Africa before the International Court of Justice, and these all concerned the situation in Namibia, as did the previous um, case between, and it's there on the screen, Ethiopia and Liberia, the contentious case, and South Africa in the 1960s. And all of these cases concern Namibia. Namibia was a mandate, was called Southwest Africa until, well, the UN started calling it Namibia in the 1960s. But it was not actually a sovereign state until 1990 with the fall of apartheid. And that's because at the end of the First World War, when the German colonies were taken from Germany and then redistributed among the victors, South Africa's piece of the pie was a mandate over Namibia. Now, it was supposed to ensure that Namibia eventually would become a sovereign state, but it didn't do this, and it actually tried to annex Namibia after the Second World War. And so this resulted in a whole series of cases before the International Court of Justice, including one that was taken by Ethiopia and Liberia against South Africa, and that led to a bit of a disaster for the International Court of Justice. The reason why Ethiopia and Liberia took the case, they had kind of been nominated by other African states who thought they were the best ones to take a case against South Africa, given that they had been members of the League of Nations. There were four African members of the League of Nations: Ethiopia, Liberia, South Africa, and Egypt. And so they took the case, which was then thrown out, where the court said that Ethiopia and Liberia didn't really have an interest in the case and couldn't proceed with it. And it was a scandal. It was even denounced by Lester Pearson, who was the Prime Minister of Canada at the time, as being a disgraceful judgment. And it set the court back for decades, really, although the court has recovered. It's got its mojo back since then. And then finally, and this is the first thing to happen to South Africa at the International Court of Justice since the 1960s, is the case that South Africa filed against Israel at the end of December in 2023. And of course, it concerns whether or not Israel has violated the Genocide Convention in the conflict in Gaza. Now, as for Israel at the International Court of Justice, as I mentioned, they also signed up to the court with the optional clause in the mid-1950s. They had a case, only one case until the 21st century, with Bulgaria, and it involved the shooting down of an El Al jet by the Bulgarian military when it was overflying Bulgaria. And the case was finally thrown out as being on technical issues. So it never went to a judgment. And as I mentioned before, Israel eventually in the 1980s withdrew from the optional clause. And so it was fairly immune to having a case taken against it at the International Court of Justice until South Africa went after it on the basis of the Genocide Convention. There have been, however, two advisory opinions requested by the General Assembly. There's a third one that's pending now at the International Court of Justice, but we haven't had a ruling on it yet. And these have been requested by the General Assembly. The first one of 2004 concerned the wall that Israel had built within occupied Palestine, within the West Bank, and the International Court of Justice concluded that the wall was illegal, that it should be demolished, that Israel had no right to build a wall inside the Palestinian territory. And then a second advisory opinion, 20 years later, in July of last year, an advisory opinion that I think is probably one of the finest opinions that it's ever issued in the history of the court since the 1940s. And in that opinion, the court said, with a remarkable degree of unanimity, that the occupation of Palestine by Israel was unlawful and that it had to come to an end. And that the reason why it was unlawful was not simply the passage of time, it had been occupied since 1967, but also because Israel was, in effect, occupying it with a view to annexing Palestine and making it part of a greater Israel. And of course, Israel has really defied both of these advisory opinions issued by the International Court of Justice, and then the case that's currently before the court. So this is a bit of the background of, Israel, South Africa, and the court. And now just a few words about what's going on at the court more generally. So there have been, since the court began in 1946, 200 cases. I think we are literally at number 200. If a state was to file a new case tomorrow, it would be case number 201. And 20 of them, 10% of them, concern the Genocide Convention, and the vast majority are based on the clause in the Genocide Convention that gives the court jurisdiction. Most of these have been thrown out on technical grounds. But it shows the interest that states have in the Genocide Convention. The other 180 cases deal with a whole range of issues. Some of them concern human rights, although that's a more recent phenomenon. Many of them concern boundary disputes, fishing zones, issues like this, treatments of diplomats, a whole range of international law issues, some of which are of great concern internationally, and some of which are really just details that arise when there are quarrels between states about various issues. The first case, dealing with the Genocide Convention, was an advisory opinion that the court issued in 1951. And although it has some interesting paragraphs in there where they talk about the importance of the Genocide Convention, the issue at the heart of it was whether or not states could make what are called reservations to the convention. And this is what a state may do when it ratifies the convention. It may say, we agree with the Genocide Convention, except for, and they make a reservation. Now, it's a shocking idea in a way, and no state has ever tried to say, we agree with the Genocide Convention, we agree not to commit genocide against national, ethnic, and racial groups, but we reserve the right to commit it against religious groups. So no one's ever done anything so outrageous and absurd as that. Most of the reservations have concerned Article 9, and that's why there are, I think, 12 or 13 states that are not exposed to the jurisdiction of the court because they've made reservations to Article 9. And most recently, just weeks ago, the court made a judgment in a case between Sudan and the United Arab Emirates based on the Genocide Convention that upheld a reservation by the United Arab Emirates and essentially threw out the case. Two of the cases have resulted in what we call a judgment on the merits. And that means they've gone the whole way through. They weren't thrown out on technicalities. And so the court then has issued important pronouncements about genocide and about the interpretation of the convention. The first one was in 2007. This was a case filed by Bosnia and Herzegovina against Serbia back in 1993. It took 14 years for it to work its way through the system for reasons that I'm not going to go into today, but that I can explain if you really need to know. But the fact is, it took many years for it to come before the court and to result in a judgment. And in that judgment, the court threw out the case uh, against Serbia that held Serbia being responsible for genocide. But it did say that Serbia had an obligation under the Genocide Convention to contribute to the prevention of genocide, that it should have done this because of its influence over the Bosnian Serb forces. And it said the Bosnian Serb forces had committed genocide in Srebrenica in July of 1995, towards the end of the wars in Bosnia, Serbia, and Croatia. Um, the court returned to in the second case dealing with the wars in the former Yugoslavia in Croatia versus Serbia. Here the judgment was in 2015. And there it just threw out the case. It threw out the case that Croatia had against Serbia for committing genocide. And in that case, Serbia had replied to Croatia by saying, well, if you say we committed genocide against you, you committed genocide against us. And the court threw that one out as well. I must say, when that second judgment was issued in 2015, I thought to myself that the Genocide Convention has no real future at the International Court of Justice, that the judges seem to be saying, don't come here. This is not where we're going to settle disputes about whether or not genocide has taken place. But this is not what has happened, and that states have responded with in recent years. We're talking now the last 5 or 6 years um, to the issue of the Genocide Convention, and seem to be saying to the International Court of Justice, we know you've let us down in the past, but we're expecting you to apply the Genocide Convention in a more dynamic way to deal with the various conflicts that are ongoing in the world. So this is for a convention that was adopted in 1948 and that shows signs of its age and appeared maybe even to have become more or less an anachronism in 2015. All of a sudden, it's as if it's been given a big dose of steroids, and it's back in action. And Megan said in her introduction that there were 5 cases that were pending. And Megan, I'm sorry, I should have updated you on the fact that one of those cases was thrown out just a few weeks ago. This was the case between Sudan and the United Arab Emirates. So the first of the 4 cases is the one filed by Gambia against Myanmar in 2019. And it's pending. We may have a hearing. The parties have exchanged proceedings, and all of those stages are completed. So I think at some point the court is going to announce that there's a date of an oral hearing. It might be later this year, more likely to be sometime in 2026. There's the case filed by Ukraine against Russia, which is a bit of an anomaly because Ukraine isn't charging Russia with genocide, but rather it's charging Russia with making a false claim of genocide. Then there's the case of South Africa versus Israel, about which I'm going to have more to say in a minute. And finally, the case of Nicaragua versus Germany, which is where Nicaragua, it's kind of Nicaragua is accusing Germany of violating the Genocide Convention and other treaties as well. But in terms of the Genocide Convention, it's saying that Germany could have influenced Israel not to commit genocide and that it's failed to do that. So these are the 4 cases underway before the court. And 3 of them, I've written those words erga omnes, 3 of them are erga omnes cases. And they are part of a broader international, and a broader phenomenon of human rights cases at the International Court of Justice. The International Court of Justice now has about 25 cases before it. I mentioned several minutes ago how there had been this case filed at the International Court of Justice against South Africa back in the 1960s. And when the court threw it out, it was disastrous for the court. And for many years, nobody went to the court. They didn't trust it. And a good friend of mine, a law professor, just retired from the University of Montreal, was telling me how in the 1970s, when he was doing his PhD at Cambridge, he had gone over to The Hague because he wanted to see a hearing. And he went and knocked on the door of the court, and somebody answered, and he said, "Well, I'm here to see a hearing." And the person who answered said, "Well, you'll have to come back later because we haven't had a hearing here in 4 years." So it was a court that had become completely inactive because states didn't trust it. They didn't expect it to settle issues and to resolve disputes. But that has slowly returned to the court, and it is now busier than ever. And the other thing that the feature of its activity is that about half of the cases before the court are dealing with human rights issues. The genocide cases to which I've referred, the four of them that are underway before the court. And then I've mentioned here 6 other cases that are up here on the screen. One that was filed by Canada and the Netherlands against Syria based on the Torture Convention. Another one that, and I put it in gray here because it hasn't yet been filed, but it's been promised by Canada, Australia, Canada, Germany, and the Netherlands, and I should have mentioned, versus Afghanistan. And the case is going to be based on the CEDAW Convention, the Convention on the Elimination of Discrimination Against Women. There are 2 cases based on the Racial Discrimination Convention that we use. We go by the acronym CERD, and this is the case that Armenia filed against Azerbaijan, and Azerbaijan filed a case back against Armenia. And then there are 2 advisory opinions that deal with issues that are really fundamental to human rights issues and that concern human rights treaties or human rights obligations. An advisory opinion on climate change, which was argued last December, and we're waiting for the court to issue its ruling. I think it's likely it will do this probably next month in the middle of July. And then another one, which has been submitted by the International Labor Organization on the right to strike. And it has not yet had a hearing, so it's still a year or so away. But what's phenomenal here is how many states are taking cases to the court. In effect, to me, what they're saying is we don't trust, we're frustrated in the political bodies like the UN General Assembly, the Human Rights Council, and above all, the Security Council with the veto. And so we want our disputes to be settled by judges on the basis of international law. It's an interesting observation, I think, because a lot of people right now are saying, well, international law, it's being violated all the time, so what use is it? But it's very clear that a lot of states think that it is useful and it is important, and it's on this basis that they're taking the cases. Excuse me, I'm just going to close the door here because I think there may be some background noise. Sorry about that. And I think the turning point at the court goes back to the thing I mentioned at the top, the Chagos Islands advisory opinion, which was filed in which was issued in 2019. And this is where the United Kingdom was told that it had to give back the Chagos Islands in the Indian Ocean to Mauritius, and that it should never have taken possession of them, which it did when it carved them off at the time of decolonization in the mid-1960s. So this was not just a blow to the United Kingdom, but it was kind of a blow to the global north, to all of the states that were colonialist or that were allied with colonial states. None of them really liked this. And it was a very positive sign that I think also encouraged more and more states to come before the court. So this is something that, of course, it could change, and the court could disappoint with one or other of the judgments, and then maybe states will be frustrated. But right now, It seems to be a popular place for states, and the judges are, by and large, living up to the expectations in that they are issuing robust and powerful judgments, and judgments where they also are often quite, there's a high degree of unanimity. And this is important. It shows a court where the judges, they make compromises. I was in a meeting this morning where people were grumbling about the advisory opinion that was issued last July because it didn't explicitly condemn Israel for apartheid, although it did say there was a violation of the Racial Discrimination Convention. But often these are compromises that are made so that they can speak with one voice or nearly one voice. It's very rare that they're going to be entirely unanimous, but they are able to achieve high levels of unanimity, and that's a great strength of the court as it stands today. So let me talk a little bit about this case now, the case between with South Africa. Um, we're dealing with the definition in the Genocide Convention. I haven't put it up, the text on the screen. You can find it. If you don't know the definition, you can Google it and you'll get it in 2 seconds. But the components, the key components that are, I think, going to be addressed and are going to be in dispute in this case between South Africa and Israel is, well, first of all, we have to have one of the punishable acts in the convention. The convention lists 5 of them. A couple of them don't appear to be relevant, but there are enough of them that apply, and I don't think there's really going to be any difficulty with this. One of them is killing members of the group. So it's clear that Israel has certainly killed many members of the group. And the other act is deliberately inflicting on the group conditions of life calculated to bring about its physical destruction. And I think, again, here we're going to have, there'll be a strong case by South Africa that this is another feature of Israel's attack on the people of Gaza. The target has to be a national, ethnic, racial, or religious group. And the court so far hasn't specified where it places the Palestinians. It calls them the Palestinian group. It may call them a national group. It may call them an ethnic group or a racial group. I think it's unlikely it would call them a religious group because the Palestinians have people of different religions. There are notably a significant number of Christian Palestinians. But one of those categories will fit. In the book I wrote on the Genocide Convention, I said that often, rather than try to find, discrete definitions of each one of these 3 groups and to try and pigeonhole a group within one of those 3, that it might be better to think of them as like posts that define a field and that groups like the Palestinians fit within them. They're described maybe using 2 of the categories, maybe even 3. But I don't see any significant difficulty with that issue. The real issue, and this is the challenge for South Africa in the case, and it's been the challenge in all the other cases, certainly in the cases that were decided in 2007 with Bosnia and then in 2015 with Croatia, is proving that these acts were committed against a protected group with the intent to destroy the group in whole or in part. And we call this the specific intent. The courts have taken the view that the intent to destroy has to be to destroy physically. So it means that cultural genocide is excluded as a crime under the Genocide Convention, although what we know of, what we call cultural genocide, can be important evidence of an intent to destroy the group physically. It may help to confirm the goal or the objective or this specific intent to destroy the group. In the case of Bosnia and Herzegovina and in the case of Croatia, this is where the case failed. The court, in effect, said what they were intending to do in the conflict was to ethnically cleanse the area, to drive the people out of the territory but not to physically exterminate them. And one of the problems here, of course, is once you've proven that the acts took place, states will say, well, we did that. We're not denying. I don't think Israel is going to deny that they killed members of the group, but they'll say we did it because we had to either defend ourselves or destroy Hamas, or that we were doing it as part of an armed conflict, that it's just a legitimate act that takes place in an armed conflict. Israel might even argue that, well, we want to get rid of the Palestinians, we want to get them out of there, and we're trying to convince them to leave. And so we're like what happened in the Balkans, where we're trying to convince people to leave rather than to destroy them or exterminate them physically. I think that in history, when we look at a genocide, we find these elements. We know that in the Armenian genocide, that the argument of the Turks was they were a disloyal minority, and we were in a war, and it was part of this was something that was brought on by the war. There was some of that in the Nazi outlook as well in the 1940s. One of the difficulties with proving the intent to destroy the group is, of course, that states don't say what they intend to do. And so the Serbs would say, well, we intended to drive them out. That was our goal, but we didn't intend to exterminate them. And there's no evidence of us making statements saying that. And so it doesn't mean you can't convict a state, hold them accountable for genocide when they haven't made such statements. But it does make it harder to prove because you're basing the proof on inferences or deductions that are drawn from their conduct. And this is a notion that's very familiar to in criminal law. We call it circumstantial evidence. And when you draw the inferences from the conduct, the general rule with circumstantial evidence is that you have to be able to exclude any other reasonable explanation for the conduct. And so, as I say, that's been the problem in the past. I don't think that this is really the problem in the South African case because we have much evidence that confirms the intent of the Israeli armed forces or of the government of Israel as it stands now. What someone called the blood-curdling, a judge at the International Court of Justice called them the blood-curdling statements that were made by Israeli officials. The one I'll never forget is the one by Yoav Gallant, who was then the Minister of Defense in October of 2023, when he said, they're all animals. He said these are not, the Palestinians are animals. He didn't distinguish between combatants and civilians. And he said, because they're animals, we're going to cut off electricity, water, food, medical care. So to me, this is direct evidence of a genocidal intent. And there are many other statements, and I've looked through the judgments in the Bosnia and the Serbia, the Bosnia and the Croatia cases. I've also looked at the submissions by Gambia in the Myanmar case. We don't really have this statements like this from the highest levels. We have more occasional comments by soldiers or combatants, the sort of things that I think feature in any armed conflict. But in the case of Israel, these are very blatant statements that betray an intent to destroy the group. Plus, I think the context, we know as well, of course, that Israel is not shy about saying that its goal is not to have a Palestinian state, but to have an Israeli Jewish state from going east, at least to the Jordan River, some say even beyond, but from the Jordan River to the Mediterranean Sea. And if they do that, and the Palestinians are still there, they're going to have a country that has a Palestinian population that's either equivalent to the Jewish population or even majority. So in the case before the court, we had, and this attracted huge attention, great media coverage around the world. There were public hearings on a request for provisional measures by the by the South Africans. They asked for 3 orders of provisional measures in the first months of 2024, and you can see what the orders were there. Israel was ordered to take all measures to prevent the commission of acts within the scope of Article 2 of the Convention. That's the definition of genocide. To prevent and punish the direct and public incitement to commit genocide. There, clearly the court is saying it looks like there is this direct and public incitement to commit genocide, and you're not doing anything about it. And also to provide, they say, to enable the provision of urgently needed basic services and humanitarian assistance. And to this day, this is not happening. And we see even in the last few days, when food is being provided in so-called humanitarian assistance, that significant numbers of Palestinians are being killed when they go to get food, which is absolutely appalling. And this is taking place, has been taking place, I think, every single day in recent weeks. What's going to happen with the case? Well, South Africa filed it at the end of 2023. The court issued an order saying you have to make your formal submission by October 24. We call this the 2024. We call this the memorial. And South Africa has done this. One of the features of the case, but it's not alone here, is that there have been a significant number of interventions by other states in the case. This is something that's permitted under the statute of the International Court of Justice, although until a few years ago, it had hardly ever been used. There were, I think, 3 cases of states that intervened in proceedings before the court. And this, too, is a sign that courts are expecting more, that states, rather, are expecting more from the International Court of Justice. And so here we have a list of the states that have intervened in the case. They intervene, they don't say it explicitly, but in effect, they're intervening to support South Africa. And there may be more submissions. As you can see, we have some European states, Spain and Ireland have intervened, which is significant. Several Latin American states, and Turkey and Libya, Maldives. And there may be more to come because the window hasn't closed for making these submissions. Israel was supposed to file what's called its counter memorial in July of this year, but several weeks ago it went to the court and said, you know, we've got a lot of work, we're overburdened, can we have more time? And the court said, yes, you can have until January of 2026. The court could then say, okay, let's have an oral hearing. Or they could say, let's have a second round. Let's let South Africa reply to Israel's submissions, and then Israel will get to reply to South Africa's. And this has happened in the Gambia-Myanmar case. It could happen, and that will, of course, add, 15 months to 2 years onto the length of the proceedings before we get to the important stage, which is the oral hearing. And I would expect the oral hearing in this case to last several weeks. There will be mainly submissions by lawyers, but there may also be some witnesses in the oral hearing. I would expect there'll be some, although it's generally not a court where you don't call witnesses in the way you would normally in a domestic case, and certainly where you would if it was a criminal case where an individual was on trial. And then we have a judgment. So the judgment, again, 2-3 years from now at a minimum, it could be longer. And this is just a feature of the procedure at the court. I think, to some extent already, people said, what's the use? What's accomplished here? And I think to some extent, it's already, changed the debate. I can tell you that at universities, my world, my universe, universities in Europe, but also in North America, in late 2023, to talk about Israel and genocide in the same breath could be a career-ending move for an academic in a university. And that all changed when the court issued its order at the end of January of 2024, because if the court considered that a charge of genocide was plausible, then how could the university administration or some other body say to someone, well, you're not allowed to talk about Israel being accused of genocide, when in fact the judges of the International Court of Justice had in effect said that. So this, I think, brings me, as you can see, it brings me to the end of my slides. I'm going to stop sharing, and then you can just see me with my background of the International Court of Justice. And so this is the case, and I think really it's time for questions or comments.
Thank you so much, Dr. Schabas, for this engaging presentation. Yes, we will open the floor to some questions. I believe there's a few in the Q&A chat box, so I'll read those out, but you're also welcome to raise your hand and ask them as well. So let me see here. We have one from Alan Whitehorn that says, is the use of the phrase ethnic cleansing drawing upon a genocidal perspective and employing the word cleansing? Is there less pejorative phrasing?
The term ethnic cleansing has, of course, been used, was originally used by journalists, and it's not a very legal term. There's no convention on ethnic cleansing, although the International Court of Justice has spoken to the use of the term and said, and I can't remember by heart what it said, but it's in the Bosnia decision in 2007, where they talk about it being the driving out of a population from its homeland, using force and committing other violations when it's being committed. I think that it properly falls under the heading of crimes against humanity, because and where it's distinct from genocide is that it's the acts of genocide in a sense, but without satisfactory proof that the intent is to physically exterminate the group. I think that's what it would mean. And maybe it's important to point out that at the International Court of Justice, because the jurisdiction in this case is based on the charge of genocide and on the Genocide Convention, the court doesn't have the fallback position. It doesn't have the luxury of saying, well, maybe you can't prove the specific intent to physically destroy the group, but it's certainly what the acts are heinous and they should be condemned as crimes against humanity. The court won't say that. All it can say, if it can't conclude that it's genocide, is, well, we don't have any jurisdiction to decide anything else. That's one of the frustrating parts of a case like this.
Thank you. We have a three-part question here. I'll start with just the first one to start. In the Convention of the Prevention and Punishment of the Crime of Genocide, Article 2 defines genocide as any one of the 5 enumerated acts. In your book, you write about other acts of genocide and refer to 4 forms of participation in the crime of genocide: conspiracy, incitement, attempt, and complicity. Which of these 2 interpretations constitutes acts of genocide? Is the question.
Okay, well, thank you for reading my book. And when I'm referring to other acts, it's because we're talking about Article 3 of the Genocide Convention. So this is maybe where there's possible confusion. Article 2 of the Genocide Convention talks about any of the following acts, and then it lists 5 acts: killing members of the group, causing physical or mental harm to members of the group, imposing conditions of life, and so on. And so those are the acts of genocide, whereas Article 3 talks about other acts, because it's not just talking about genocide. That's one of the acts that's listed in Article 3, but also complicity in genocide, conspiracy to commit genocide, and a couple of acts that can be committed without genocide being committed. So direct and public incitement is a violation of the Genocide Convention, even if it doesn't actually result in people committing genocide. And obviously, the same is true of attempt. You could charge attempt, which is in Article 3. And obviously, if someone actually commits genocide, you're not going to charge them with an attempt, although they obviously attempted to do it. Because once you actually commit the crime, we don't talk about attempts anymore. But, conceivably, you could stop genocide being committed, and then it would be subject to prosecution or subject to a violation of the convention for being an attempt.
Thank you. Another question we have here is, can you speak more fully on the challenges of specific intent in this case and how the ICJ might be moving beyond its position in the Bosnia and Croatia cases?
Well, as I said in the presentation, I think that one of the differences between this case and all of the other cases that have come before the court is this very substantial volume of evidence about that point to a genocidal intent, and I think that's going to weigh heavily on the court. But I also think that the court is going to be I think it's likely that the court is going to move beyond the position it took in the two cases, the case of Bosnia and Herzegovina and the case of Croatia, and adopt a more generous approach to the notion of the proof of genocidal intent. It was very harshly criticized for having such a strict standard for the proof of genocidal intent in those two earlier cases in 2007 and 2015. A recent example, I mentioned the intervention. So we have 12 or 13 of them in the South Africa case. We have fewer. I think we have 8 or 9 in the case dealing with Gambia and Myanmar. But there's a very interesting intervention in the case of Gambia versus Myanmar by 6 Western countries. The one that comes first, because they're in alphabetical order, is Canada. So Canada, Denmark, Germany, France, Germany, Netherlands, and who have I forgotten? Denmark, Canada, France, Germany, and UK. 6 of them jointly filed a submission, an intervention in the Myanmar case in late 2023, where they argued that the court had taken too severe an approach to the proof of genocidal intent. They quoted a dissenting judge in the case in 2015. The Brazilian judge in 2015 had said to the court, "This is too strict. You're making it impossible to prove genocide." So these 6 Western states they didn't know that South Africa was going to take a case against Israel then. They could not have anticipated it. But they had prepared this because they wanted to support Gambia's complaint against Myanmar. So they said, loosen up. Don't make it so hard to prove genocidal intent. And they gave examples where they said the court should look to these facts to contribute to the evidence of intent. One of them was the persecution and the attacks on children. They said when the children are victims, this is a sign of genocidal intent, and the court should emphasize that. Again, they could not have anticipated what was going to happen in Gaza, where, as we know, a huge number of the victims are children. And secondly, they said, and you have to emphasize forced displacement, ethnic cleansing, if you want. They said you have to emphasize the importance of forced displacement within the territory. And of course, the Palestinians in Gaza have been subject to, I don't need to explain, Israel's ordered forced displacement constantly throughout Gaza over the last 20 or 21 months. So, the South Africans are going to invoke this opinion by these 6 Western states, but it's a sign also, I think, what's happening. And as I say, I think that the legal people in Ottawa, if they had a second chance, they would say, let's not do it this time. I mean, they played their hand, they played their card, and there it is. But I think that view is shared by many states, and that it's going to, people talk about political influence on the judges at the court. So this is not really political influence, but it's states saying, you're our court. This is our convention. We own it, and we're expecting more of it than what you've been giving us. And I think that I think that the judges, many of them, are going to be very responsive to that.
Thank you. We have another one here. Considering that the precautionary measures have not been effective, how is it possible that the court allowed Israel to delay their response until January 2026? And is there a way to accelerate proceedings considering the grave consequences of the delays?
Um, well, I don't think there's any way to accelerate the proceedings. The the delay is unfortunate. I think that the court gave. I think the court's position is that they want to have states. They don't want a state complain that their rights were violated. In a way, it's bad news for Israel because it's the judges of the court saying, we don't want to give you any excuses. We'll give you 6 more months if that's what you need, because we don't want you coming and saying you didn't give us enough time to prepare our submissions. So I think you can interpret that, um, it's a kind of a poison gift for Israel in a way. They didn't have to ask for it, but certainly they probably want to delay the proceedings. Mind you, with the delay, it looks worse and worse for them every day as things go on. But this may all change. I mean, we are sometimes in a case at the International Court of Justice when we dealt with the case of Croatia and Serbia. They'd had peace for 20 years when it was finally settled. Um, but this is a conflict that's ongoing, obviously. So yeah, I don't think there's any simple way to do it. I think that when Israel makes its submission, then it will be up to South Africa to say we'd like to have another round because we want to answer what Israel has said. Many states would want to do that. I think that South Africa may say, no, let's get into court. When I
Thank
say get into court, I mean get to the oral hearing.
Right. And is there a mechanism to stop genocide in progress as it takes years to get a judgment? And then this is a two-part question. The second one, is the judgment enforceable?
Sure. Well, it is enforceable by the main mechanism that can stop the genocide, which is the United Nations Security Council. But we have a little problem at the United Nations Security Council. I don't need to draw a map of everybody what the problem is there. Um, it's also enforceable more, in maybe a more indirect way, because there are several states, including Canada, that are helping Israel, helping it with moral support, with political support, with various forms of some of the military support. This is the case of Germany, the United Kingdom, and so on. And there's litigation in those courts where there are attempts, some of them have had some success, to block the assistance coming to Israel. There's another way to do it is to impeach Donald Trump and then get Bernie Sanders elected president of the United States. That might do it, you know. I mean, there are different mechanisms, but it is a court that doesn't have any mechanisms of its own. It counts on the political, and that's the design of the system. The court can lay down the law, but then the implementation of its rulings are left to the political sphere. And they definitely changed the temperature. Even these orders that were issued last year in favor of South Africa against Israel helped build momentum, criticism of Israel, but they obviously didn't stop it. And part of the problem is that Israel has, a handful of very loyal friends who are providing it a lot of support, including, I mean, people debate about whether, who's the dog and who's the tail, but there's some dog wagging a tail, whether it's the United States and Israel's the tail or vice versa. I'm not sure. But it's pretty hard to when the United States is so devoted to Israel to find an appropriate political forum where you can change this.
Thank you. One here, how does the ICJ have jurisdiction over the cases you mentioned that rely on CERD and CEDAW?
Well, those other conventions have clauses like the Genocide Convention. So there is provision. There are several treaties, several in the field of human rights that enable, have a pathway to the International Court of Justice, and both of those, the Convention on Women's Discrimination Against Women, the Convention on Racial Discrimination, There are some other ones sitting out there that may lead to litigation because it's clear that the legal officers in different countries are looking more closely at taking cases to the ICJ. And so there are a number of other treaties. One of them is the Refugee Convention, which provides for taking cases about refugee law before the International Court of Justice. So we may see that happening. There's a case that's really related to refugees, but it's being taken under the under another treaty by Lithuania against Belarus, but it's really a refugee case. And so there'll be more of this as lawyers are creative and find new openings um, for the court.
This one is from Frank Chalk from Concordia. Will Israel impress ICJ judges with the defense that the cabinet members who urged Israel to treat Palestinians like animals, etc., were not part of the war cabinet, which directed Israeli armed forces policies on the ground?
Well, first of all, let me say hi to Frank Chalk. Frank is a great scholar in the field of genocide studies, and it's nice to. Well, I'm not hearing from you, Frank, but I'll see you sometime soon, I hope. Um, yeah, I mean that could be an argument that they make. We'll see, how much we'll see what Israel's submissions are, and whether they want to even deny those statements, and whether they want to kind of how should I throw Ben Gvir and Gallant? I mean, he was part of the war cabinet, I suppose, but some of them definitely were not. Does Israel want to throw them under the bus? Or will they stand by them? These will be difficult political decisions they'll take. I'm sure that when the time comes to write that, and maybe this is why Israel needs more time, I expect that their counter memorial, as we call it, has to be signed off on by a lot of people. And there'll be a lot of sensitivity about the consequences of it. So, yeah, I don't know. The question there, of course, it's one of the great challenges in these cases is to prove the intent of a state. And it's probably, the terminology in the Genocide Convention where it talks about the specific intent is there because in 1948, when the General Assembly was adopting it, most of the members of the General Assembly thought that they were drafting a convention on criminal law and that they were drafting a provision that would go in a criminal code and that it would be used in a trial for an individual. And if they had a clear vision that this was also a convention that was going to be used to charge a state with actually committing genocide, something that was not clarified in law until 2007, really, in the judgment of Bosnia versus Serbia. But until then, there'd always been a dispute about it, and there certainly was in 1948. But if the judges, if the drafters of the convention in 1948 had understood that, they probably would have used a word other than intent. Because how can a state have an intent? States have a policy, and we probably would have used a term like that, in pursuit of a policy, and that would be more accurate. And then you could say that some people in the government weren't part of the policy, that they were kind of outliers on the policy, and so their statements don't reflect the policy. Then you'd be talking about the policymakers rather than the individual intent of individuals. I expect those statements will be viewed as more of a kind of emblematic of a mindset in the cabinet and in the leadership of Israel at the time.
Thank you. We're coming close to the 20-minute mark, but there's one more question here. How do you account for anti-Israel and anti-Semitic bias influencing the process and outcome of this case?
Well, when we say anti-Israel, it's not a synonym with being anti-Semitic. I think someone can be critical, very critical of Israel, without being an anti-Semite, and I include myself in that category. Come from a family of Holocaust survivors. I could not be an anti-Semite. I don't have an anti-Semitic bone in my body. But I think that at the court, I don't think that should be a concern. I mean, Israel labels everything anti-Semitic, and anything that goes against Israel, they say it's anti-Semitism. You know, when Prime Minister Netanyahu was charged at the International Criminal Court, he said this was like the Dreyfus case. You know, Dreyfus was a victim of an anti-Semitic conspiracy in France at the end of the 19th century. And there's a big difference between Dreyfus and Netanyahu. Dreyfus was innocent to start with. He was framed up by lying witnesses and forged documents. It's not the same thing at all. But, you know, it's a bit of a mantra in Israel. Um, I don't, you know, the judges are they're a diverse lot from different countries. Um, there's certainly nothing visible to indicate that there's even a hint of anti-Semitism amongst the judges, and I wouldn't expect that. And, you know, we find it's very hard to put your finger on who's anti-Semitic now because some of the biggest supporters of Israel are people who have a history of being anti-Semites. I mean, look at Orban in Hungary and the movement he represents. I mean, he's hardly, I would have thought, hardly a friend of the Jews. And I could say the same about others, Marine Le Pen in France and the far right in Italy, are all forces known for being anti-Semitic. Even, let's say, I don't want to I don't want to tar everybody with this brush, but some of the so-called Christian Zionists, the right-wing Christian fundamentalists in the United States, they wouldn't traditionally have been thought of as being friends of Jews, exactly. So, you know, this is so yeah, I think we should just stop referring to anti-Semitism unless we have something that's clear evidence of it. But critical of Israel, yes, I think there are many statements. I don't think there's a judge at the International Court of Justice who would quarrel with the idea of Israel's right to exist as a state. I don't see that anybody would try to argue that before the International Court of Justice. They would go down in flames. That would be totally inadmissible. But you would certainly find in their advisory opinion last year is clearly a message that the Palestinians have a right to a state. So I think it's very clear from the judgments that they endorse Israel's right to exist. That's not an issue. The only issue is, can Palestine have the same thing that Israel got, which is their own state?
Thank you so much, Dr. Schabas, for this very important session today. And thank you so much to the participants for tuning in and for your great questions as well. If you enjoyed this session, the Institute will be hosting a webinar on Tuesday, July 8th with John Allen, the former Canadian ambassador to Israel and senior fellow at the Munk School of Global Affairs and Public Policy, on the conduct and response of third states to Gaza. So this session will explore the reaction of the Biden and Trump administrations, the Canadian and European governments, and some of the major powers, including India, China, and Russia. And more information on this can be found on the Zoryan Institute's website under the events page. And finally, if you've missed any portion of this webinar today or would like to rewatch it, it will be available. The recording will be available and circulated to all the registered attendees, and also available on our website in a few days as well. So we hope to see you in a few weeks. Thank you, Dr. Schabas, so much.
Thank you. Thank you for having me.